Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing K-1 fiancé visas and a couple of requirements that I think are often sort of on one hand sort of overlooked, and on another hand they're sort of looked at as if they're too heavy, are the meeting requirements in the single status affidavit. What are we talking about here? Well, one, in order to petition for a fiancé visa, both parties have to be legally able to marry one another. Now, there's also a meeting requirement, as we've discussed in other videos. You need to go ahead and have met your fiancé, your foreign fiancé, within 2 years of filing a petition for a K-1 fiancé visa. But then the issue becomes, well, what if we met and I was still legally married? It can be a vexing one, depending on the circumstances of your case. Now, for the meeting requirement, understand that legal status regarding marriage may not necessarily apply, or it may not be any kind of a factor that will have an impact on the meeting requirement analysis. That being said, there is, again, you have to be legally free to marry in order to petition for a fiancé. So again, you may have met each other, for example, when you were on the tail end of your marriage, for example, and you may not have been legally divorced. That may be okay for purposes of the meeting requirement, but for purposes of the petition itself, again, you have to have a legal ability to marry the person that you are seeking to get a K-1 fiancé visa for. For this reason, this can create complexity in these kind of cases, and for this reason, for those who are unable to really sort of parse out where exactly they stand with respect to the Immigration Nationality Act and how it pertains in application to the ability to petition for a K-1 fiancé visa, it may not be a terrible idea to contact a legal professional, gain some insight and guidance into how best to proceed.